Hello, this is a free Florida bar approved CLE called Significant Florida DCA Cases handed down in the first quarter of 2026. I'm going to be going over a PowerPoint during this one free credit hour Florida bar approved CLE. If you would like a copy of the PowerPoint, you can contact me at wizard@floridadcawizard.com or cullen@cullenobrienlaw.com. The Florida Bar reference number to get the 1 hour credit for this CLE is 260-3258N, 260-3258N. If you are watching this, you're seeing it on YouTube. The original broadcast, I had technical difficulties and it didn't record, so I'm re-recording it without an audience and putting it on YouTube. There were people who attended this and there was an audience of people. In any event, this CLE will cover significant opinions in all 6 district courts of appeal from January 1st, 2026 through March 31st, 2026. I went through each of the approximately 400 written opinions handed down by all 6 DCAs since January 1st, 2026 until March 31st, 2026, and I selected approximately 50 significant cases to review. The significant cases are what I think is significant about the cases. Obviously, please read the cases. Please say, think what you want to think about the cases. But this CLE covers things that I think are significant. Now, obviously, some of these cases are very long. So I'm just picking out things that I think are practical for my future use, my current use, or other people's practice areas. Here are some rough statistics on the written opinions between January 1st, 2026 and March 31st, 2026. When I say written opinions, I don't mean the citation opinions where it just says affirmed and then a bunch of string cites, and I don't mean PCAs. When I say written opinions, I am defining it as a couple paragraphs text, some message other than affirmed, other than one word. So, or denied. So the first DCA had 36 written opinions. The second DCA had 45. The third DCA had 135. The fourth DCA had 86. The fifth DCA had 42. The sixth DCA had 50. In this CLE, I'm grouping the roughly 50 opinions into these 9 areas. This is my grouping, and these are how I'm categorizing them just to talk about them for ease of reference. Like I said before, there are many things that these cases handle, but I am breaking it out into these subject areas: case management, sanctions, family law, criminal law, punitive damages, contracts, summary judgment, medical provider cases, and then a category of interesting other cases. I'm going to spend a little longer with some cases, and some cases I'm not going to spend much time. We only have an hour, and there's about 50 cases. One more thing about this PowerPoint, when you have it, each case subject area has a cover page. So these are the case management cases we're going to go through. Every time you see the case, there's a hyperlink, so you can click on it, and I downloaded the opinion to Dropbox, and you can read it. Each of the DCAs have PDF links, but sometimes the links expire over time. So I downloaded the copy of the PDF that's on the DCA's website and put it on the Dropbox, so it's always there, so there's no expired link. For case management, we're going to talk about the Chrysalis case. It's a new application of Binger, a pretty significant case because prejudice is no longer required in the 6th DCA. Walmart, same holding, just about a month later. The Nguyen case, which deals with failure to appear at a pretrial conference. The Perpall versus State case, a denial of a continuance to secure a witness's appearance. Huggins, failure to appear at trial. Aguilar, untimely witnesses. Ansaroff, attorney abandonment. State versus Vergara, witness failure to appear. Rodriguez, responsibility for seeking a default. Dejanovic, partial default, and Dunak versus Dunak, responsibility for setting a hearing. One more thing, when I write these cases, I put the county and the lower court in the title, just so that if in case that's helpful to you. Okay, so Crescelius versus Rizzano, 6 DCA case, DUI negligence case. The defense disclosed experts 2 months after the disclosure deadline. And the late disclosure was due to quote unquote internal office mismanagement, and the defendant's experts had been non-responsive. The experts' reports showed that the crash was the plaintiff's fault because the motorcycle was going too fast. And the trial court concluded that the defendant's reasons for the late disclosure was egregious and just did not think that internal office mismanagement and non-responsive experts was a good enough excuse to blow the disclosure deadline, especially by 2 months, and kept the expert out. There was a plaintiff's verdict finding the defendant to be 100% at fault, and damages were awarded of 8.25 million. And had this on appeal, the argument was had these expert reports that showed it was the plaintiff's fault come in, this verdict wouldn't have been so, and the trial court should have entered into a different analysis, like prejudice. Look at all this prejudice that would have happened with not allowing these experts. And the 6 DCA, in a groundbreaking case, my opinion's groundbreaking, has basically says there's no prejudice required, no prejudice analysis required. Binger has been misapplied, and quote, when a party fails to meet a disclosure deadline set forth in a case management order, the trial court may strictly enforce the order and exclude the undisclosed or late disclosed evidence. While our sister courts have held that Binger requires a trial court to find the opposing party would be prejudiced by the introduction of an undisclosed or late disclosed expert opinion before excluding the opinion, we find that Binger imposes no such requirement. It's about 91 pages, this Crescelius case, of the majority opinion and then some concurring opinions, and they certify conflict with the other DCAs, and it's a bunch of cases they certify conflict with. But if you're in the 6 DCA, it seems like the 6 DCA is saying trial order deadlines, case management deadlines are like appellate deadlines. The deadline doesn't care why you didn't file it on time. The trial court can treat it like an appellate deadline. You missed the deadline, you missed the deadline. A deadline is a deadline. Don't care if there's internal office mismanagement. Don't care if your experts haven't been responsive. You missed the deadline. Pretty groundbreaking case. Walmart versus Wynn, another 6 DCA case, decided in the same vein as the Crescelius case. It was a slip and fall. There was ankle and nerve damage injury. There were new medical records produced the day of the discovery cutoff, and the defense expert was deposed after receipt of the records. The defense expert changed his opinion as to the cause of the nerve damage, and the trial court excluded the new opinion and said that the untimely disclosure of the new opinions per the case management order was not proper, even though the defense expert was deposed after receipt of these records the day of the discovery cutoff. There was a plaintiff's verdict, and there was exclusion of the defense expert. On appeal, you shouldn't have disclosed. You shouldn't have rejected the defense expert. Otherwise, it wouldn't have been a plaintiff verdict. And the 6 DCA said no. Just like what we said in Crescelius, the trial court is permitted to strictly enforce the case management order and exclude the undisclosed opinion without considering whether the other party would be prejudiced by the introduction of the undisclosed opinion. A deadline is a deadline is a deadline is a deadline. No prejudice required. Interesting to see how this develops. Obviously, the Florida Supreme Court will hopefully take this up and decide whether Binger's correctly decided or issue a new case or what have you. Stay tuned. So the second DCA case, Nguyen versus Williams, it was a car accident negligence case. The case management order stated at least one trial counsel per party must physically be present, at the pretrial conference, and that failure to appear may result in sanctions and or dismissal of the case. The plaintiff's counsel failed to appear at the pretrial conference, and the case was dismissed. In the motion for rehearing, the plaintiff's counsel showed that 2 days before the pretrial conference, she sent an email to the defense counsel saying, hey, I'm not really feeling well. I can't attend the pretrial conference. Do you think, asking the defense counsel, do you think you in the court can kind of like reschedule everything? And there was no response by defense counsel. And then the day before the pretrial conference, the plaintiff's counsel had her husband, who's also a lawyer, send an email to defense counsel saying, hey, just so you know, my wife has this illness. She's confined to bed and otherwise unable to function, either physically or mentally. And she's not going to get better by tomorrow. Can you guys just like, can you and the court reschedule the conference? This is the plaintiff's counsel asking the defense counsel. This was in, and then the plaintiff's counsel's husband asking the defense counsel. This was in the motion for rehearing. The plaintiff's counsel said, even though the husband's an attorney, she didn't want him to appear at the pretrial conference because the case management order stated one trial counsel per party, and she didn't think like a coverage attorney would fit the bill. So let's just reschedule it. The motion for rehearing was denied, even though at the pretrial conference, the defense counsel emailed plaintiff's counsel and husband and said, the judge is waiting on one of you to appear. So in the motion for rehearing, the plaintiff's counsel said, look, we told defense counsel all this stuff. And at the hearing, he sent us an email saying the court is waiting for you guys to appear, even though he knew we had emailed him and he didn't tell you about all these emails. Motion for rehearing still denied. And the second DCA upheld it because the motion for rehearing was not backed with sworn evidence. There's a Pyrrhic victory, I guess, because at the end of the second DCA's opinion, the second DCA says, in response to the defense counsel not telling the court that all these emails had happened about the plaintiff's counsel being sick and the request to reschedule, we construe this failure by defense counsel to advise the trial court about the emails to be in the nature of gotcha litigation tactic. They were critical of it, but they didn't overturn it. So it's like I said, it's a Pyrrhic victory. There's Per Paul versus State, a third DCA case. It was an attempted murder. The defense witness was unavailable at 3 p.m. on the Friday of the jury trial, and the defense asked for a continuance until Monday. The witness gave a deposition at the courthouse on that Friday, but apparently had to leave the courthouse because his girlfriend was in labor. Interestingly enough, that was not backed by sworn evidence either, but the third DCA took that as a sworn fact. And the witness that needed to have the deposition taken would have said that someone other than the defendant committed the crime. The trial court denied the continuance until Monday. The trial went forward. It was a guilty verdict, and the third DCA reversed it. The third DCA basically said the defense counsel did not need a writ of bodily attachment to justify continuance, and also said Florida courts have held that trial courts abuse their discretion and denying continuances where defendants merely served or attempted to serve subpoenas to witnesses. The next case, Huggins versus SafePoint, breach of contract case, and the parties were notified about who's going to trial after the calendar call by the judicial assistant. I'm sure all of you have been in that scenario where, hey, I've got 25 cases for trial, you're number 4, you're number 10, whatever. And then what do you do after the case management conference? Here, like is common, the judicial assistant is going to tell the parties and their counsel who's going to trial. And the counsel failed to appear at trial, and the case was dismissed as a sanction. You didn't show up for trial, case dismissed. The rehearing motion was denied, even though the counsel who failed to appear had not been included on the emails from the judicial assistant. So the judicial assistant's like, okay, you guys are up, come to trial on Monday, and one of the counsel just didn't get the emails. And the fourth DCA reversed the dismissal. The circuit court apparently has self-created a process whereby multiple counsel whose cases are set for trial on the same date may receive a blast email containing an updated trial schedule. While this process appears well-intended, its flaw is that when a case is ultimately reached for trial, if the party inadvertently has not provided their email to the court's judicial assistant, that party will not receive notice that their case has been reached for trial. So I guess it's a tautology. If you don't get notice for trial, how can you be penalized? At the same time, one could imagine a lot of abuse in this system by someone who's trying to game it, potentially. Uh, it went to my email. The email went to junk. I don't use that email, so on and so forth. But in any event, I guess the move is to confirm that everybody got the email by responding saying, yes, I got the email. That may be a quick fix, or a notice being filed in the court file definitely would solve this. But don't I not I think the trial court did everything correct, as well as the judicial assistant. Just seems like it was a mix up with the email. Aguilar versus Rojas. This is a car crash negligence case. The plaintiff's expert witness was struck due to untimely disclosure, and there was a petition for writ of certiorari saying that the trial court failed to apply Binger in this balancing test of prejudice versus strict deadline. And this is during the case, so there hadn't been no trial yet, but just said, hey, this is a problem. Appellate court, can you please tell the trial court to have this expert or use a different balancing test? And interestingly enough, the third DCA said, we're not going to grant your petition for writ of certiorari, which is a departure from the essential requirements of the law and irreparable harm that can't be addressed post judgment. So is the third DCA saying that failure to apply Binger is not a problem? Are they trending towards the six DCA's opinions? I don't know. I know this was before those significant opinions, but it definitely is part of the mix of whether Binger applies. Because if there needs to be a prejudice analysis, you would think prior to a judgment, it would be a time to do it. Some just food for thought. Okay, Antaroff versus Lurlis is a foreclosure case. The attorney abandoned the client, and there was a default judgment. The client found out about the default and foreclosure sale and hired a new counsel to vacate the default. The trial court vacated the default, and this was affirmed. The holding was the trial court did not grossly abuse its discretion in finding excusable neglect. The counsel did not appear at the hearings and did not inform her of case developments, never responded to opposing counsel's attempts to contact him, and didn't inform the client of documents that were filed. So the fact that an attorney abandoned the case and didn't do anything, let's not penalize the client, and so the default was vacated. State versus Vergara. It was a petty theft case. The state's witness checked in on Zoom but did not appear at the courthouse 2 hours later when the jury was selected. This witness saw the defendant stealing, but the case was dismissed for non-compliance with the trial order of having witnesses ready for trial. And the trial court said in the colloquy, take an appeal of my pretrial order. For the fifth time, I would really love some resolution on it. The court said there was some alleged practice that he was not happy with regarding readiness of trial. And my pretrial order requires witnesses to appear here for check-in 2 hours after trial time, and case dismissed. Take an appeal, and they took an appeal, and the trial court was reversed. The third DCA said, we certainly understand and sympathize with the trial court under the circumstances presented, and we recognize the trial court's attempt to fashion and enforce its standing pretrial order. There are, however, limits to what a trial court may do in pursuit of such laudable objectives. Dismissal of the case for a witness's failure to appear is generally not a viable alternative, as such dismissal implicates separation of powers principles. A trial court can't sua sponte tell the executive branch that their case needs to be dismissed. That's up to the executive branch, or there has to be a motion presented. Interesting case. Rodriguez versus Bryant Permit Service. Construction litigation, the defendant defaulted, and the trial court entered an quote-unquote order to take action based on eligibility for default final judgment. And if you don't do it, it shall result in dismissal of the case without further hearing. The case was dismissed for failure to file a motion for default judgment, even though there was an impending calendar call, and this was reversed. And the third DCA said, we sympathize with the trial court's dilemma and acknowledge the trial court's need to enforce its own orders, but plaintiff's counsel and plaintiff's attorney did violate the order, but basically plaintiff's counsel was confused between default and default final judgment and thought there already was a default, and maybe the court was confused and there was a calendar call coming up where everything would be resolved. That was the plaintiff's attorney's excuse. And so the third DCA said that was a good enough excuse, reverse the dismissal for failure to file a final default judgment. Dejanovic versus Block, it was a fraud case. There were 3 defendants. 2 defendants defaulted, 1 defendant answered, and the trial court found that the 3rd defendant was stopped from defending the case because of the other 2 defaulted defendants. When the 2 defendants defaulted, they admitted to certain things in the cause of action, and this was imputed, according to the trial court, to the 3rd defendant, that his alleged misrepresentations were imputed to everyone, and this was reversed. The 3rd DCA said technical defaults by 2 defendants do not constitute admissions against the 3rd defendant who answered and denied and is defending themselves. Okay, Dunac versus Dunac, a family law case. The magistrate made a ruling, and under the Florida family law rules of procedure, if you want to challenge a magistrate's ruling, you need to quote unquote seek to schedule a hearing date. Even though the husband had a request in the motion for review of the magistrate's ruling, a request for a hearing, that was not enough to satisfy the rule. The 4th DCA said, here the husband did ask a request for a hearing in his motion to vacate, but he did not take further steps like contacting the court or opposing counsel. Without such further steps, the husband did not try to quote unquote acquire or schedule a hearing date within the meaning of the rule. So here are some sanctions cases. Jakowska is about fee reduction. Wolfson, incarceration for failure to comply. Gasik, malicious prosecution. DG Auto, an enhanced fee. Banker's Life, an hourly rate case. First Florida, an indefensible fees for defending an indefensible case. Okay, Jakowska, a divorce case. And like I said before, I'm not going to go spend a lot of time on every case. In some cases, I'm going to go through much more quickly. Please read the cases, see what other things jump out to you. I am just identifying things that are interesting to me or significant in these cases, and I'm grouping them so maybe you can see compare and contrast with some of the cases. And when I start to get to summary judgment, you'll see compare and contrast some fact patterns, some different areas of law among and between different DCAs. Hopefully, it'll be self-explanatory as we go on. Jakowska was a divorce case. The trial court reduced the fee award to the former wife because there was unnecessary behavior from the wife that caused an increase in fees. So, all this increased litigation, even though the former wife won, fee reduced for vexatious litigation, for lack of a better term. This was reversed. To the extent the trial court may have intended to deduct some portion of the former wife's fees, it was required to make specific findings that support the reduction factors and explain what portion of the fees incurred were occasioned by the misconduct in question. So each hour needed to be pegged to some excessive litigation and then a reduction point by point, not just, hey, you over litigated this, I'm going to cut your fees generally. It had to be more delineated. Wolfson versus Paredes, a divorce case, a party was put in jail for failing to provide documents and for failing to pay the private judge's fee. I'm sure you've heard this. What's the worst case scenario if I don't comply with this court's order? Well, I guess technically you can be put in jail. Well, you can cite to this case because this party was put in jail for failing to provide documents and failing to pay the private judge's fee. This was reversed because the trial court did not allow the party sufficient time to purge the contempt and made no findings as to present ability to comply. The quote from the case, without the present ability to pay from some valuable asset, the contemner holds no key to the jailhouse door. There must be some indication in the record that the trial court considered the contemner's ability to comply with the sanction. The Gasik case, condominium litigation, the owners successfully defended a claim at a jury trial, but before they got to the jury trial and won that claim they defended, they filed 6 counterclaims that they had lost at summary judgment prior to winning at trial the claim that was filed against them. So then the owners, because they wanted a jury trial on the claim that was filed against them, sued for malicious prosecution for having to defend a claim that they won. And the first DCA said that the trial court correctly dismissed the malicious prosecution claim because the owners lost their counterclaims. Quote from the case, a plaintiff must show a favorable termination of all claims in an underlying action. Here, the owners greatly multiplied the scope of the prior action in pursuit of their counterclaims, and having lost, it's not right that they get to sue for malicious prosecution because they didn't win everything. So maybe the thought is, if you're going to defend a claim and then seek malicious prosecution, don't cloud the record with claims that or issues that you may not win. Very important concept. I'm sure you've been consulted before. What happens? Can't we go after them if we win? Maybe, but you better not lose anything in any counterclaims to make that avenue viable. DG Auto Group, federal wage case. This may be confined to federal wage cases, but there are some principles here that, like I said, could be applicable. The plaintiffs won a jury verdict, and there was an enhanced fee for plaintiffs' counsel that was upheld by the third DCA. The third DCA said defendants and counsel admitted to intentionally evading their litigation obligations and ignoring this court's orders in the hopes that plaintiff would abandon the case. Enhanced fee justified. Baker's Life versus Boru. It was a fraud case arising out of insurance billing. The trial court awarded fees at $5.25 an hour, and this was reversed because the fee agreement had $4.50 an hour. And to get more than what's in the fee agreement, the fourth DCA said, the agreement must indicate that the parties anticipate a fee award exceeding the agreed upon amount. Practice pointer for fee agreements, if you want to get more than the agreed fee and you think there's some fee shifting, you got to put it in the fee agreement because the fourth DCA makes clear you cannot get fees that are higher than what's contemplated by the fee agreement. The first Florida international case, a wire was sent in error and there was a lawsuit to recover the wire. Money sent, oops, didn't mean to send that. The other side wouldn't give it back, so there was a lawsuit to recover the wire. And the trial court, according to the third DCA, properly sanctioned the defendants under the Cozell factors for their defense of essentially an indefensible case. A mistaken wire, just give the wire back. There's no justification to hold on to a mistaken wire. I went to the Miami-Dade Circuit Court website and pulled the trial court order that was affirmed. It's a 23-page trial court order. If you're ever looking to file a Cozell motion, you should look at this order. A lot of really interesting stuff. And these kinds of indefensible punches going everywhere kind of case. And I'll just read a couple quotes from the 23-page order. The other side had filed a frivolous complaint against plaintiff's real estate license and a baseless motion to refer plaintiff's counsel to the Florida bar, both in clear violation of Florida Bar Rule 4-3.4. There have now there now have been multiple hearings and multi-year delays of what the court believes is a straightforward dispute involving a mistaken wire. The other side refused to make themselves available and coordinate with this court's judicial assistant to allow this case to proceed. A lot of delay tactics, etc. It's a very good read if you're going to file a Cozell motion. Here are some punitive damages cases. Roque versus Sweezy, competing claims for punitive damages. Meralda versus Mitchell, unsecured pipe on a trailer. Turo versus Mobley, a car tire blowout. DeCharia, a fraudulent inducement case. And Weiss versus Weiss, email extortion. Roque versus Sweezy, former lovers sued each other, and there was a claim for defamation and then a counterclaim for defamation. And both sides were granted leave to file claims for punitive damages. And both sides, used the same evidence as part of their respective evidentiary proffer. The same photographs, 911 call, video still, testimony from third parties, and medical records. And the trial court said, okay, both of you guys proved an entitlement to seek punitive damages. There was an appeal of that, and one of the parties said in the appeal, the trial court can't do that. Either one side is really bad and the other side isn't, or vice versa. But both sides can't seek punitive damages at the same time. And the third DCA said, no, there's no law saying that both sides can't seek punitive damages at the same time. So that award was, that ruling that both sides could seek punitive damages at the same time based on the same evidence was affirmed. Meralda versus Mitchell. I cited this in this PowerPoint. This opening of the opinion is very interesting, and maybe it comes up if you're ever writing a motion for leave to file punitive damages. It's poetic. When a defendant's negligent actions are so outrageous in character and so extreme in degree that an average member of the community would exclaim, outrageous, then the law may move beyond merely compensating the plaintiff and then award punitive damages. Okay, this case, this fact pattern, and you're going to see maybe differences in other similar fact patterns among different DCAs, was not outrageous. There was an unsecured, according to the 6 DCA, there was an unsecured pipe in the back of a trailer sticking out of the side, and it struck a person in two parked vehicles. And the trial court said, yeah, punitive damages because of the driver's decision to continue driving with an invalid or expired driver's license, knowing that he had a prior substantially similar accident just 2 days prior to the accident, and his history of license suspensions was the willful and wanton conduct that subjects his conduct to punitive damages. Outrageous. 6 DCA said, no, not outrageous. The past driving record was not relevant. Driving on an expired license was not relevant, and an accident 2 days earlier was not germane. There's another case, Turo versus Mobley. A car tire blew out in a rental vehicle that was obtained on Turo. One passenger died, and there were multiple injuries to other passengers. And the trial court allowed punitive damages against Turo because the vehicle had been rented 79 times, and 55 of the pre-trip inspection photographs indicated that the tire pressure warning light was illuminated. The renter was told the light is on all the time. One of the sensors isn't working, but the tires are great. The tires are great. Shortly into the drive, the rear tire of the vehicle blew out, causing the vehicle to fishtail, veer off the road into the median grass, and flip several times. Trial court said, yeah, that's outrageous. This was reversed by the 6 DCA. As to Turo, Turo did not have constructive knowledge of the problem with the tire. Even though Turo advertised and promoted the vehicle didn't fail annual inspection. No renter reported the tire problem to Turo. There was testimony from Turo that had Turo known that they would have known this, they wouldn't have allowed the car to have been rented, and there was no knowledge imputed to Turo. The next case, DeCharia versus Roots. Leave to assert punitive damages was affirmed in a fraud case, but the 5th DCA clarified something, saying basically, because it's a fraud case, it doesn't necessarily mean you're entitled to punitive damages. You have to make some extra showing. Quote, while it is true that a claim for fraudulent inducement to contract necessarily involves the element of intentional misconduct, sufficient allegations in a complaint to state a claim for the contractual tort do not per se meet the evidentiary and procedural requirements. You got to show more than just allege something that's fraudulent. And here they actually alleged something more. Weiss versus Weiss. A mother sued a daughter for extortion, fraud, malicious prosecution, and fabrication of evidence. And the 3rd DCA found there was a sufficient proffer for entitlement to seek punitive damages. Quote, the mother presented personal emails from the daughter allegedly showing an intent to extort and scare her through threats to have her improperly declared incompetent to be able to control her properties, and several other threats of fraud and forgery. I thought this was an interesting case because the mother was unable to file an answer brief due to the attorney withdrawing, but she still won on appeal. So she didn't even have to file a brief and won. All right, here are some contract/arbitration agreements cases. We got Moskowitz regarding the burden for initiating arbitration, Anderson Service about a subcontractor signing an agreement, Sudbury, an agreement to arbitrate within another agreement, Vias regarding contractual jurisdiction. Moskowitz, probably my favorite case out of the 50. There was a motion to stay given an arbitration agreement and a sales contract. So the sales contract said you got to arbitrate. There was a lawsuit, and the defendant filed a motion to stay pending arbitration because there was an arbitration agreement in the contract. Can't sue here, got to arbitrate. That was granted. Well, the plaintiff did not initiate arbitration. Case just sat there. I don't know if you've ever been involved in that situation, but I have, and it's a very interesting dilemma. What do you do? The whole point of an arbitration agreement is to avoid the court resolving it and to enforce the arbitration procedure. But If they don't want to enforce the arbitration procedure, why should you? I mean, isn't it their burden to enforce the arbitration procedure? Not a lot of cases on what you're supposed to do. Here, this may be a pretty good case if you're in this situation. 5 years later, after the motion to stay, the plaintiff moved to lift the stay, saying, hey, the defense defaulted. They should have sought arbitration. They moved to stay pending arbitration, and they didn't seek arbitration. And the trial court denied the motion and said, wait a second, the burden for starting arbitration is on you, the plaintiff, because you filed the lawsuit. So if you want to seek arbitration, that's up to you, not up to the defendant to start arbitration for you. And this was affirmed. And the third DCA, like I said, in terms of instruction for other cases, went on and provided some interesting dicta. With a simple affirmance, we would normally stop there. But especially considering Florida's new case management standards, we have sympathy for the trial court's dilemma in having this open case indefinitely on its docket. So in remanding, the third DCA said the plaintiff has 10 days to initiate arbitration or the court can dismiss it. So potentially this is a case to be cited when somebody moves to stay arbitration. And by the way, see Moskowitz, they have 10 days to start arbitration or their case can be dismissed. You need to have some teeth in the language in the order. I know a lot of courts have teeth in their motions to stay arbitration, but it's not always the case, and there's not a lot of law on it. So this is why I really like this case. Anderson Service, it was a construction lien. Lien transfer bond was posted. The plaintiff sued the defendant as surety. The trial court compelled arbitration pursuant to the subcontract, but this was reversed on appeal because the subcontract only binds the plaintiff and the subcontractor. The defendant was not a party to the subcontract, and neither the subcontract nor the subcontract's arbitration provision were incorporated into the lien transfer bond. And the surety bond did not contain an arbitration agreement and did not incorporate the subcontract or the subcontract's arbitration provision. Sudbury versus Florida Woman Care. This is an employee discharge case filed by a medical doctor, and the trial court, according to the fourth DCA, should have compelled arbitration given the incorporation of arbitration in the documents of the company in which the medical doctor became a member. So when the medical doctor became a member, there was an agreement to arbitrate within other agreements that were all incorporated into him becoming a member. He signed, quote from the case, he signed the letter of transmittal acknowledging he was becoming a party to the asset purchase agreement as a pivoting owner and was bound by the terms of the asset purchase agreement. Thus, by becoming a party to the asset purchase agreement, the doctor expressed an intent to be bound to the terms of the management services agreement. Agreement to arbitrate within other agreements. Okay. Bias versus American Van Lines. It was a contract case regarding moving household items. The contract said if a lawsuit becomes necessary to resolve any dispute, such suit shall and must only be brought in circuit or county court in and for Broward County, Florida, governing federal law, and the defendant consents to jurisdiction in Broward County, Florida. The trial court found personal jurisdiction based on this contractual provision alone, and the fourth DCA reversed. The statute that allows a trial court to find personal jurisdiction based on a contract alone says that the contract has to have consideration of at least $250,000. It can't be governing federal law. It has to be Florida law governing. So these requirements weren't met, and there needed to be an independent basis for finding jurisdiction besides just the contract. Here are some summary judgment and tort cases. Quadrago, slip and fall on a banana peel at Walmart. Walker, fall off a bench at Chick-fil-A. McWhorter, slip on a battery case at Tampa Bay Rays Stadium. Verone, shooting at Publix. Kincaid, slip on a gel pack at Walmart. Quadrago, there was a slip and fall on a banana peel at Walmart. The summary judgment for Walmart was reversed. The trial court, according to the first DCA, the trial court erred in ruling as a matter of law that a banana peel on the floor for 8 minutes in a spot that would have required employees to turn their heads at least 90 degrees prohibited the store from having constructive knowledge of the alleged dangerous transitory foreign object. Quote, a trial judge cannot conclude as a matter of law whether the duration of which an object was on the floor is sufficient to create an issue of fact, because that is a question within the jury's province. This is the language from the court. I read it a couple times. I wouldn't write a sentence like that, whether the duration of which an object was on the floor is sufficient, but I'm reading it directly from the first DCA case. Anyway, Banana Peel, Walmart does not win on summary judgment. Compare this to some of these other fact patterns. Walker versus M633, fall on a bench at a Chick-fil-A. The patron fell while standing on a bench looking for her toddler. She was looking around and fell off the bench. Summary judgment for Chick-fil-A was affirmed. There is no evidence that the bench created a dangerous condition, nor was there evidence that the bench had been in continuous and obvious use as something on which an adult could stand. It is not foreseeable that plaintiff would step up onto a bench designed for sitting. So Chick-fil-A wins on the bench. Walmart loses on the banana peel. The McWhorter case, slip on a metal battery case at Tampa Bay Rays Stadium. The trial court erred in granting summary judgment for the event services company. The trial court correctly found there was no duty to warn, but, quote, the duty to warn and the duty to maintain are distinct, and compliance with one does not always mean compliance with the other. Although the dangerousness of the abandoned battery case might have been open and obvious, a reasonable jury could have concluded from this evidence that the event services company breached its duty to maintain the stadium rotunda in a reasonably safe condition. Barone versus Publix, terrible case, a shooting inside of a Publix, and a grandmother and her grandchild were shot randomly, complete random stranger, and the trial court granted summary judgment for Publix, and the fourth DCA said that was correct. The argument for why summary judgment should not have been granted for Publix, which was rejected by the fourth DCA, was that there were gun statistics of 448 gun incidents and 139 gun deaths in national grocery store chains from January 1st, 2020 to May 14th, 2022, including 5 deaths at Publix stores. And Publix had active shooter trading. But the fourth DCA said the fact that Publix had active shooter trading did not create a foreseeable zone of risk, and nationwide statistics of shootings do not establish that it was objectively reasonable for Publix to expect the specific danger of a random act of gun violence. Kincaid versus Walmart, slip and fall on a gel pack at an aisle near the meat department of a Walmart. The trial court properly granted summary judgment for Walmart here. Walmart wins on this one. The plaintiff did not point to evidence that Walmart or its employees knew of a ruptured gel pack in the aisle, or knew of a slippery gel substance in the aisle, or had put it there, and the plaintiff failed to meet her burden to point to evidence from which a jury could find that Walmart had either actual or constructive knowledge. There was no evidence that a dangerous condition occurred with regularity and was foreseeable. So banana peel, Walmart loses. Gel pack, Walmart wins. Anyway, I'm tongue-in-cheek, but it is interesting to see how these fact patterns play out. Okay, medical provider cases. Cordero, boilerplate medical expert affidavit. Brown, a hospital patient attacked another patient's daughter. Ray's, complications from elective cosmetic surgery. Lopez, an Instagram posting of a leg injury. Molinet, liability for corpse storage. Cordero, medical malpractice case, and the pre-suit expert report is what you see on the screen, and it was not sufficient to meet the statutory requirements for pre-suit investigation. Such vague, conclusory, and boilerplate language failed to comply with the statute. We are left scratching our heads as to what reasonable grounds for medical negligence may be, and this concept of shooting first and ask questions later, figuring out later in the litigation what the purported negligence was, is not going to fly under the statute. Brown versus Florida Health Sciences Center. This is a difficult case to conceptualize. Terrible facts. And I'm not minimizing any of the other facts. I'm just saying this one here. I'm sure you've been in a hospital room and there's been another patient. Well, here, the other patient had a psychiatric break, and the patient here the plaintiff, her father just had spinal surgery, and the daughter is getting her father better from spinal surgery or saying goodbye after the surgery or what have you, and the patient in the same room is causing issues. And the daughter says to the nursing staff and the hospital staff, "Hey, can you do something about this patient? He's really like freaking me out." And they came in, saw the concerns, and didn't do anything about it. And then when the hospital staff left, the daughter was attacked. And so the trial court granted summary judgment for the hospital. The trial court said the daughter was deemed a trespasser because she remained in her father's room after visiting hours, and the hospital owed no duty to the daughter. And this was reversed on appeal. Plaintiff was saying goodbye to her father. Even if staff had asked her to leave, a reasonable jury could conclude that the nurses allowed her to remain to complete her visit. A jury could conclude that the hospital took responsibility for the patient's behavior and owed a duty to protect the plaintiff. Reyes versus Blue Cross elective cosmetic surgery. There was a hospitalization with an infection and post-surgery, and there was denial of coverage by the health plan. This was affirmed. There was no genuine dispute that the hospitalization was linked to the elective procedure because plaintiff was treated for post-operative infection. What I find interesting is that there was still no genuine dispute, even though the plaintiff had filed an affidavit from the cosmetic surgeon saying that the hospitalization was not part of the elective procedure. Lopez versus Kendall, son was in a motorcycle crash, and prior to the death at the hospital, some EMTs started to take pictures of the son's leg and put the pictures onto Instagram and were like tagging each other on Instagram. And then the son died. The father found out about these pictures on Instagram and sued for intentional infliction of emotional distress, invasion of privacy, and negligence. And the third DCA found that the trial court properly granted summary judgment against the father. The thought process was the father was not present when the EMT took a photo or when he posted on social media. The photo taken was posted of a person who was alive, not dead. At the time, the person was alive, the son had not died yet, and there was nothing that in the pictures, you could identify the son. And in any event, the EMT was not acting in the course and scope of his employment with the hospital. Molinette, the funeral home didn't store nor transport a cadaver correctly, and that caused the family to need to do a cremation because the body was in such disrepair, they couldn't do an open casket. And summary judgment for the funeral home was reversed under the Florida Funeral Cemetery and Consumer Services Act because it does not require a showing of malicious conduct for recovery. However, the funeral home was entitled to summary judgment on the emotional distress claim because there was no evidence that the funeral home engaged in wanton, malicious, or outrageous conduct. Some family law cases. Haxel versus Haxel, credit for post-separation house payments, VELIF, restrictions from attending public events, Crossan, custody of a pet, Triguerio, bad excuse for failure to appear at trial, Ramos, majority time sharing. We have about 10 minutes left, so I'm going to go pretty quickly to get through the rest of these cases. Haxel, the court said when that's a court should not credit a spouse for making post-separation house payments when that spouse was the primary income earner generally responsible for paying the mortgage. So because the husband paid the mortgage without the wife's financial assistance during the marriage, the court should not have credited him for continuing those payments after the wife moved out of the house. Velif, the trial court prevented the wife's current husband, a non-party to the case, from attending public events involving the child. This was reversed because the current husband did not receive notice and he wasn't a party to the case, and this violated his due process rights. And it seemed like the former husband was trying to resurrect a failed injunction against the current husband from doing things. Crossan versus Feely, the trial court gave divorcing parties joint custody of the dog, and this was reversed because you can't give joint custody of a pet. Triguerio, a wife failed to appear at trial, and the court proceeded anyway, taking evidence and rendering a final judgment. The denial of rehearing was affirmed. The wife who missed trial was a licensed attorney, and her excuse for not coming to trial wasn't believed, and the trial court was right to think that she voluntarily absented herself from Florida with the minor child. Perhaps that affidavit is good to compare to somebody else you think has a bad excuse for not attending trial. Ramos versus Hunter, the trial court improperly awarded majority time sharing when the relief was not requested prior to the hearing, nor noticed for a hearing. Here are some criminal law cases. Kent, brake lights. Kelly, consent to enter a dwelling. Ward, leaving the scene of an accident with property damage. Palveda, leaving the scene. Vargas, bolstering in a DUI case. Kent versus State, an officer's observation of brake lights is sufficient evidence to provide probable cause for a violation for running a stop sign. The brief illumination of the brake lights suggests a defendant's vehicle merely slowed a rolling stop rather than coming to a complete cessation of movement at the stop sign. Probable cause, brake lights, sufficient. Okay. Kelly versus State. The state offered sufficient evidence that the ex-girlfriend revoked her consent for defendant to enter her house, even though the ex-girlfriend testified that he was, quote unquote, always welcome to her house, even unannounced prior to the incident. Ward versus State. Crashing into a ditch on the highway alone is insufficient to establish the damage element of the crime of leaving the scene of an accident with property damage. That's the 4th DCA. Consider this next case. 2nd DCA. The defendant was properly convicted of leaving the scene. The trial court correctly concluded that under the plain language of the statute, the defendant could not legally have left the scene, not even to report the accident to the nearest police station, without first ascertaining the condition of the smaller pickup's occupant. Inherent in the requirement that one remain at the scene is a requirement that one remain at the scene at least until he or she has ascertained the condition of the other persons involved in the accident. Vargas versus State. There was no improper bolstering in a DUI prosecution for the arresting officer to testify at trial that not every person stopped for suspicion of DUI is arrested. By saying some people meet the criteria for DUI, some people don't. This statement was deemed to not be improper bolstering in a DUI prosecution. The last set of cases, these are just interesting cases. Williams and Cardenas, 2 different cases regarding Daubert hearings. Pulio, fraud in real estate. Walgreens, burden shifting instruction for lost evidence. Ruiz, basis for a psychological evaluation. Northeast 32nd Street, entitlement to costs for partial victory. Webpard Corporation, email service under the Hague Convention. Zapata, overly repetitive voir dire. Rufinach, no experts for fee hearings. Williams versus Leesburg, 5th DCA case, which held that the trial court was not required to hold a live Daubert hearing and could instead rely on deposition transcripts, medical literature, and other documents in conducting the Daubert analysis. So the trial court didn't need to have the expert on the stand and didn't need live testimony. Could just look at the papers. But the 3rd DCA, compare this to the 3rd DCA's reversal in Cardenas. The trial court erred in making Daubert findings based solely on the affidavit and argument of counsel. I don't know that the 3rd DCA went as so far as to say that you always need a live Daubert hearing, but my takeaway from both of these cases is the safest bet, especially if you think you're going to win and the other side is going to challenge on appeal, is to have the expert testify live at the Daubert hearing so that they can't say that the court didn't consider everything, or at least get a stipulation from the other side that the expert is not necessary for the court to undertake the Daubert analysis, thereby precluding them from arguing the opposite in an appeal if they lose the Daubert hearing. Pulio versus Cohen. The plaintiff stated an actionable triable claim for fraud where the purchaser of the property, the purchaser, not the seller, the purchaser of the property, misrepresented true intentions in the use of the property and the identity of the buyer in order to obtain a discounted price. The defendant actually wanted to redevelop and resell the property. And the court said the plaintiff had no duty to ask more questions and could state a cause of action for fraud when the purchaser misrepresented the true intentions and what the purchaser was going to do with the property. Fascinating cause of action. Walgreens versus Cho, the trial court gave an erroneous burden shifting instruction as a sanction for lost CCT footage in a slip and fall case. Quote, the trial court's imposition of a burden shifting sanction after Walgreens rested its case and contrary to its pretrial announcement resulted in Walgreens having defended against plaintiff's claim that it was negligent without notice that the burden was on Walgreens to prove by the greater weight of the evidence that it had no actual or constructive notice of a foreign substance on the checkout lane floor. Next case, Ruiz versus de Arbalis. The council statements alone were insufficient to warrant a basis for a psychological evaluation in a family law case. Yet another case that attorney statements are not evidence to support some substantive issue. No evidence was presented, no witnesses were called, and no testimony was taken to establish that Ruiz's mental condition was quote unquote in controversy, or that there was good cause for a psychological evaluation. Northeast 32nd Street, a party was entitled to cost for winning a property claim after dismissing the rest of the claims. Didn't win everything, but was entitled, well, because other claims were dismissed, but the claim that was won, entitled to cost. Webpark Corporation versus Diaz. Lots in this case, but the pullout I have is apparently the Hague Convention does not prohibit email service. Zapata versus State. The trial court properly prohibited the defense from asking overly repetitive voir dire questions regarding the believability of children. The last question, which was the objection to which was sustained. Now, are you all open to the idea that a child could be making up these serious allegations as a way to control who has custody over them? Rufinok, this is another sea change case by the 6th DCA, where the 6th DCA literally says, we understand that this opinion will be a sea change in civil litigation in Florida. The 6th DCA held a trial court need not always conduct an evidentiary hearing or receive expert witness testimony concerning the reasonableness of attorney's fees before granting an award of attorney's fees pursuant to a statute, rule, or contractual provision. Trial court need not conduct always an evidentiary hearing or expert testimony to determine reasonableness of attorney's fees. Sea change, very fundamentally different case than other precedent. Okay, we're at an hour. This CLE has covered significant opinions from all 6 district courts of appeal from January 1st through March 31st, 2026. I reviewed 400 opinions. I picked out 50 that I thought were significant. Your CLE number is 2603258N, 2603258N. Email me at wizard@floridadcawizard.com or cullen@cullenobrienlaw.com to get a copy of this PowerPoint. Thank you very much for attending. Have a nice day.